And we're live. Share screen. Share. Yay. All right. So I thought this was hilarious, and I am going to go over it for your benefit as well as myself. And I'm going to give you an idea on where I think we're going to lie at the end of this. All right. So this is a motion to extend time to respond to motion. All he's doing is asking for more time. That's it. There's nothing else in there. So, uh, pursuant to Federal Rule of Civil Procedure Rule 6, moves the court for extension of time to respond to LVMPD's motion to strike plaintiff's complaint at ECF number 10. Let's just for shits and grins, FRCP. Uh, let's look up Rule 6. So we're going to share this tab instead. Computing time, etc. Last day, next day, legal holiday, extending time. I think this is part of what he's doing for. When an act may or must be done within a specified time, the court may, for good cause, extend the time on motion, with or without motion or notice, if the court acts or a request is made before the original time or its extension expires. So that's what he's doing. Simple, easy peasy, lemon squeezy. So remember, this is just a motion to extend time. The motion is made based on the attached memorandum of points and authorities, the pleadings and papers on file herein, and any oral arguments allowed by counsel at the time of the hearing. I've notified defendants of my intent to file for sanctions under Federal Rule of Civil Procedure Rule 11 because their motion lacks any factual or legal basis and is only meant to delay and harass. Now, remember, the only thing that this motion is for is a motion to extend time to file a response. He is asking for a delay while at the same time accusing LVMPD of delaying. Defendants were notified on, All right, there you go. Defendants were notified on July 18th, 2023 and have till August 8th, 2023 to withdraw their motion under the safe harbor provisions of Rule 11. I guess we should probably go to Rule 11. Why not? Since we're doing this, because I'll get a million stupid questions if I don't go through every little detail. So sanctions. In general, after notice and a reasonable opportunity to respond, the court determines that Rule 11B has been violated, yada, yada. Actually, this is one it's going to be. A motion for sanctions must be made separately from any other motion and must describe the specific conduct that allegedly violates Rule 11B. It must be served under Rule 5, but it must not be filed or presented to the court if it's withdrawn or corrected within 21 days after service or another time. So California has Rule 128 Code of Civil Procedure 128.5. Same thing. You prepare the motion. You serve the motion on opposing counsel. They have 21 days in order to basically withdraw their motion that you think is frivolous or harassing or whatever. And then if they have not withdrawn their motion within that 21-day period, then their next step is to file your next step is to file the actual motion for sanctions. So that's where we're at on that. So they request until August 15th, 2023 to respond to defendant's frivolous motion. That is classic Chiliism right there. Excuse me. That is Floyd channeling Chiliism. But again, remember, the only thing we're asking here, we're not arguing any of the Rule 11 stuff, right? We're not arguing that because that is in a different motion that we're not supposed to present to the court yet. So all we're arguing is a rationale for us to extend the time, for the court to extend the time. And just that right there, just what he said right there, full stop, if he'd stopped right there, would have probably been sufficient for the court to grant his motion to extend time. But he doesn't stop there because he's stupid. And by him, I mean Floyd Wallace. LVMPD has no factual basis for their claims. Well, this has nothing to do with the motion to extend time. So why are we talking about it? I don't know. In LVMPD's motion, no factual assertions are supported by a declaration or affidavit, and the attached document has no verification. Pursuant to Federal Rule of Civil Procedure 75D, All right, well, let's go. Since we're looking up these federal rules of civil procedure, we're going to go and this is the federal rules of civil procedure. These are the current ones. The most recent ones, the last time they were amended was December 1, 2020. They get updated every 6 years, I believe. I think it's every 6 years they redo them. I just pulled that out of my ass, and I don't know if that's true or not now. I think I know it, but we're going to Google that. How often are the federal rules of civil procedure updated? Question mark. All right, so take that last bit about they're updated every 6 years with a huge grain of salt, because I don't know why I know that. All right, so huge grain of salt on that. Where are we at? Okay. So we're going to look at Rule 75 now. 75. What? I am so shocked. What is this? Rule 75 was abrogated. That means it is no longer in effect. It was abrogated to reflect repeal of the statute providing for an appeal from a magistrate judge's judgment to the district court. This rule number is reserved for possible future use. So it had dealt in 1997 when it was abrogated. It had dealt with appealing from a magistrate judge's judgment to a district court. It had absolutely nothing to do with declarations or affidavits being attached to motions. So the question becomes, where did that come from? And we could probably find that out. Massachusetts District Court Rules. We're sharing this tab instead, and we're going to go to Rule 7.1, which I had covered previously. So, I mean, how come I remember that these were in the rules and he didn't? Submission of a motion. Right here, this is 7.1, motion practice B1. A party filing a motion shall at the same time file a memorandum of reasons, including citation of supporting authorities, why the motion be granted. Other affidavits and other documents setting forth or evidencing facts upon which the motion is based shall be filed with motion. So Massachusetts, the District Court of Massachusetts, had a local rule that required people to file a declaration supporting the facts asserted in their memorandum of points and authorities. But then we go to Nevada District Court local rules. And I believe it's clicky. Why no clicky? There we go. And I forget exactly where it is in here, but we're looking for motion. Local rule 7.2. Let's just do it this way. What page is it on? No, not those. Local rule 7.2, civil practice 39. Page 39. All motions, here we go, must be in writing and served on all of the parties who appeared. The motion must be supported by a memorandum of points and authorities, period, full stop. The motion and supporting memorandum of points and authorities must be combined into a single document. So a memorandum of points and authorities is something that says these are the facts, this is the law, and this is the application of the facts to the law. That's what a memorandum of points and authorities is. Sometimes it's called a memorandum of law. So there is no requirement in Nevada, and that's where the Las Vegas Municipal Police Department is, and that's where this lawsuit is. There's no requirement in there for them to have a declaration or affidavit attached to the document. The motion is not supported and cannot be corrected by a reply because the supporting declaration must be served with the motion. Well, that's wrong on every single level. Even if, he continues, LVMPD's attorney had included a declaration of his statements, it appears that he lacks personal knowledge of at least one of the facts. Further, LVMP statements include hearsay from non-parties and statements that in general are irrelevant to this case. Now, I could be wrong, and I probably am wrong, but the allegations that are being made are supported by links to YouTube videos. So the fact that Chili said those things is true. Whether or not they are true, whether or not the what's in those statements is true or not, that is a different topic. So for example, if Chili gets on a video and says, "I'm the king of Ohio," right? If Chili says that, you could use that video. It's not hearsay to prove that Chili said the thing. It would be hearsay to use it to show that Chili is in fact king of Ohio. And I already see stupidity about ChatGPT and stuff, and just knock that bullshit off. This isn't a ChatGPT issue. ChatGPT is not writing this. And unless you can prove it, I would suggest that you not make the allegation, because it's just not funny. Like, having heard ChatGPT 5 bazillion times, it's not funny. Like, come up with something original, for fuck's sake. And statements are in general are irrelevant to this case. Well, it's not irrelevant to the motion. So there you go. LVMP's reasonable inquiry into the evidence, as required by Federal Rule Civil Procedure Rule 11, would have simply revealed that one complaint was reference material for the other. Well, that is something that you can't know. They can show that they showed the two were very similar, and they have the statements by Chili saying that he is in fact assisting Floyd. LVMPD fails to include evidence of the illegal practice of law in the filing of my complaint. Well, no, Chili filed it. He said he filed it, and by filing it, he, according to the Federal Rules of Civil Procedure, he signs off on it. Let's see, representations to the court. By presenting to the court a pleading, written motion, or other paper, whether by signing, filing, submitting, or later advocating it, an attorney or unrepresented party certifies that the best of that person's knowledge, information, belief, formed after an inquiry under the circumstances, yada, 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 yada. So filing documents apparently for other parties is, at least in the state of Nevada, at least if the allegations by LVMPD are true. There you go. If those allegations are true, by Chili filing it for Floyd, he was practicing law. So if those allegations are true, and I don't know or care if they are, LVMPD fails to say that there would be evidence of the illegal practice of law in the filing of my complaint should they have the opportunity for further investigation. I think they just said it was the filing of the complaint itself that was the unlicensed practice of law, unauthorized practice of law. Instead of requesting relief for plagiarism, plagiarism is not a legal thing. Like, everybody copies everybody's motion. It is standard practice and procedure. It is expected. these aren't copyrighted works. These are law in motion. There are motion banks. There are form. Some of the practice guides will have form motions. They'll have like, this is the general form of the motion, and you copy those things and you just plug in your facts. It's already got the law in there, and you're off to the races. Most law firms, public defenders will have motion banks. The district attorney will have motion banks. These are already written motions written by somebody else, and you just plug in your facts. A lot of the larger law firms will have motion banks because you file the same sorts of motions over and over again. And like, one of the standard practices in one of the law firms that I work for is, hey, didn't you write a motion on such and such? Yeah. Can I have a copy of it? And you know that you're going to copy it. Everybody knows you're going to copy. It's not a problem. So you don't request relief for plagiarism. It's not a thing. LVMP requested unrelated relief without any supporting evidence related to the illegal practice of law during the filing of my complaint. Well, except for all the allegations that they made, right? Further, LVMPD offers no evidence that Jose de Castro is not a licensed attorney in whatever state statutes they are claiming were violated. No state statutes were cited. Well, I don't know about that. I thought they did cite some statutes. But here's a fun little thing. We are going to go to admit to Nevada District Court bar. For admission to the Nevada District Court, you have to prepare a motion, you have to log in, you have to pay the admission fee, and you have to take an oath. So here we go. Attorney admissions. Let's do that one. So the court, the state bar the Nevada District Court, the United States District Court of Nevada, knows who is and is not licensed to practice in their court, because in order to practice in their court, you first have to be an attorney who's admitted to practice before the Supreme Court of Nevada, and a good moral and professional character may apply for the bar to this court. So you have to show that you are licensed to practice in the state of Nevada. You have to, someone who is a member of the bar of that court has to prepare a motion to admit you, and then you have to pay the admission fee of $212. And then that's it. You take an oath. The clerk emails you instructions for making arrangements to take the oath. I mean, I am admitted into the Eastern District of California, and I didn't even have to take an oath. I just had to. I think I had to pay like $250. Bada boom, bada bing. So how would the court know that that Chili de Castro isn't a licensed attorney? Well, because the only place that it matters for Chili to be licensed is to be admitted to the bar of the District Court, United States District Court for the state of Nevada. That's it. That's how, and the District Court knows who is and who isn't. It says B. Well, and again, just remember that this is all supposed to be just a motion to extend time to respond to their motion. It's not supposed to be a response to their motion. B. This court may issue sanctions on LVMPD, their attorney, and anyone that files or submits the paper. And again, what does this have to do with the motion to extend time? Nothing. LVMPD's frivolous motion completely lacks any factual or legal basis and is clearly only meant to delay the need for a responsive filing, while LVMPD's frivolous motion is pending, as indicated in LVMPD's reference to Carter versus Penzone, and to harass de Castro or his associates. Well, how would this be harassing de Castro? First of all, how would that motion to strike be harassing de Castro? Because de Castro isn't involved in your case, Floyd. De Castro is not your attorney. He's not practicing law. He's not writing your motions. He's not giving you legal advice. So how would this be harassing de Castro? De Castro is not a party to your case. De Castro wasn't served a copy of this motion. How is this harassing de Castro or his associates? You dummy. Did you, Chili, did you stop to think for a fucking minute before preparing this? The cost imposed by LVMPD's motion on me and on the judicial system could have been avoided by a reasonable pre-filing inquiry. What is it costing you, Floyd? What is it costing you? You're pro per. unless you're paying someone. Are you paying someone, Floyd? What is it costing you? What is it costing you? A reasonable attorney would, how do you know what a reasonable attorney would or wouldn't do, Floyd? Would have not found this motion's request for relief to be well-founded based on the evidence or lack thereof in this motion. Well, it's what a court is going to do. That's what so why are you talking about what a reasonable attorney would do? Is there a reasonable attorney standard? Is that like a reasonable police officer? What is a reasonable attorney standard? A lawyer must distinguish a fact from an inference he seeks to press on the court. Well, that is interesting. It is unprofessional conduct to represent inferences as facts. Well, he was making allegations. He was making factual allegations. Rule 11C3 authorizes the court to order sanctions on its own to deter future frivolous motions. Well, yeah, I think the court is aware of that, but you are in effect moving the court for these sanctions, which, you know, we just talked about this. You're required to not make your arguments. You're required not to move for all this stuff until you've given them the 21 days. And yet here you fucking are arguing this. Isn't that weird? I wonder if anybody does get sanctions, I'm going to bet it's not LVMPD. I'm going to bet that. I'm not saying you're going to get sanctions, Floyd, but if anybody does, I would bet it's not LVMPD. Rule 6 authorizes court to extend time. Yes, it does grant the court the authority for good cause to extend time before the original time or its extension expires. Courts in the circuit have allowed extensions of time while safe harbor periods run down. That's fine. Here, plaintiff has shown good cause related to a safe harbor period for a Rule 11 sanctions motion. I think he went way above and beyond it, so he requests the court extend it. So therein ends the lesson, and we're going to go do the standard humiliation ritual, because why the fuck not, right? Fake and gay. That's me. Time. Using up all the YouTube's bandwidth again. Boomers. That's me. Hi, Kim Working. Insert cock joke. I see what you did there. I made it in early. That's what he said. Ba-dum-boom. Hello, Michael Hall. Hello, Jeepster. Hi, Stephen. You're welcome for taking the time to sort out the legal stuff for you. You're going to like my video, and I can't stop you. Well, that's true. I can't stop you. You do what you're going to do. Merb your voice, us, like a deeply seductive cup of sex. My voice, us, like that. My voice, us, just like that. Chili needs more time to work on this. He's busy grifting for an accused child abuser. Well, accused child abusers are different than convicted child abusers in that they haven't been convicted yet. And everybody's entitled to a defense. And if the court has granted you bond or bail conditions, then why is it a bad thing for people to give you money for bail or bond? Because the whole point of being out on bail and or bond is to allow you to continue to make money so that you can afford to fund your defense and work on your defense. So, like, I don't get it. I don't get why everybody is so like quick to rush to judgment. I mean, Fabio agrees. Like, cool. Let the court sort it out, you know? Let the court sort it out. The last 4 copyright strikes from Chile were overturned today. Really, were they? Well, let's check that out. Uh-oh. The rape train cometh. He's got one in his sights. Oh, he got her. He got her. Yeah, a little brown leghorn. All right, we're going to go to the Creator Studio, and we're going to go to copyright. We're going to wait, content. Hold on a second. Filter. Copyright. Oh, there we go. Still removed. So, let me show you what we're doing with here. It's still removed. That's a Chili copy. Fuck off. That's a Chili copyright right there. So I'm still copyrighted by him. I honestly expected Chili to be getting better at this by now. Instead, he somehow keeps getting worse. Well, that's because he doesn't have a core basis of understanding, and it's not that he's getting worse. It's just he's getting into new and exciting areas that he's unfamiliar with, and so his standard repertoire of all I do is file a complaint and then basically duck for the next however many months it takes isn't really working out. Chili fails in his motion again. I mean, Floyd failed. Probably. Wait, what? Chili strikes have been overturned. Isn't that unfair and unjust to our constitutional law scholar? Well, I wish. We all know this is zero chance Floyd wrote this zero. Well, yes, we all know that. Thank you for stating the obvious, Jose. I appreciate it. I wouldn't have figured it out on my own. I mean, I wasn't making jokes about it the entire time, but I mean, it's that keen eye, Jose. It's that keen eye. Chat GPT. Chili's the king. All right. Merb needs a drink. I have a probate hearing in the morning that I'm not really keenly looking forward to, so I'm probably not going to have any alcohol tonight, which is a sad thing. I would love to have a drink. All hail the king. Okay. Still on Rule 11 site. Yeah, buddy. Just like what Google has when dealing with lawsuits like with Chili. Yes. Did Chili write this motion? Probably. We all know the answer to that question. No, we assume the answer to that question. The only way it could have been more obvious if Chili wrote this is if he signed it. Yes, it is pretty obvious. Embarrassing to him, but not harassing. Probably, yeah. I would say that. Merb, you just asked if Chili even thought. Of course he didn't. He can't. He does think. He's not stupid. He is uneducated, and he's the king of Dunning-Kruger. And his lack of education, his pride, and his Dunning-Kruger all join forces like the like the Power Rangers to form a super idiot. But he's not stupid necessarily. Why do lawyers use such words? Why not? Who is this? New phone, who dis? Merby. Nice. Jesus. Where's the annoying cop? Well, he's here now. Ask and you shall receive. I clearly use the word accused. Well, yeah, but like you're basically trying to smear him out the gate. And why is it a problem for him to fundraise for someone? You know, if he's fundraising for him, if you think that the person he's fundraising for isn't going to get the money, then how about you not donate? But unless you can prove that Chili's siphoning off money, then why not just like chill and be cool about it? You know, I love all the Karens running over here to tell on him, man. Like I get it. You don't like him. Congratulations. Why do you think I'm talking about your copyright strikes? Do I have access to your YouTube studio account? Oh, the last four. You mean your last four? Okay. I get it. Mea culpa. Merb, I think Sargent was talking about the strikes Chili hit his channel with were overturned. I think we just figured that out, but thank you for clarifying. Did someone ask Merb and Kay responded? Someone did ask Merb and Kay responded to that question. Okay. Did you just assume Merb's possessive pronouns? It's California. I could change him at will. Okay. I come to your streams for your lighthearted sarcasm and the rooster. Well, sometimes it's lighthearted. Sometimes I just get done. If he's using it for research, has been giving increasingly incorrect answers over the past 3 months. I strongly suspect that Chili and or people in cahoots with Chili are using a copy of LexisNexis provided to them by discussing laws. Discussing laws said that when he got like the single attorney version of it, they gave him 2 licenses, and he was letting someone else who was helping Chile research use his other license. So I assume that's what's still going on. There are a lot of LexisNexis citations in his briefs to district court filings, district court cases, and that's not something that would necessarily be what ChatGPT would be pulling up, but that is something that LexisNexis would be pulling up hot and heavy. That's what Chile wants, is someone to say his words wrong to sue you fair slander. Okay. So using that data then to assist him in determining what is in his motions will lead to increased incorrect motions. That is a fair assertion. I just don't think that ChatGPT is playing as big a role as people want it to be. Somebody started off with that particular allegation, and next thing you know, everybody's running around with it as the gospel truth. But the reality is nobody fucking knows what Chile is using. I do know from Delete Laws. I sat down with him and had lunch with him, and he told me that he had a LexisNexis subscription, and it came with 2 licenses, and he was using one, and he was letting someone who was assisting Chile use the other. Would you be willing to review Sean Paul Reyes has a new lawsuit against the commissioner of the New York Police Department? Would I be willing to do it? I probably would, but not tonight. I've got a headache. The best way to get me to review something is to post it in my Discord channel. And I'm not just trying to drive people there. I don't watch all these auditors that you guys do, and I'm not up to date. I don't watch a lot of this stuff anymore. I used to enjoy watching First Amendment auditor videos, and I really don't anymore. I still get a kick out of some of the legal shenanigans, but I would never know what Sean Paul Reyes was doing. So if you really want me to comment on it, post it in my Discord. I will probably take a look at it, and if it looks like it's at all interesting, I will probably review it. So there you go. And that ends the evening. Oh, hold on. We got one more snuck in at the bell. How hard will it be for the lawyer to prove that Chile is still filing paperwork for Wallace? Okay. So let's look at the facts here. Chile's not a party to the lawsuit. So the court is not going to want to do a lot with Chile. The court doesn't really fucking care if Chile's practicing law or not. The court's goal is to get this lawsuit wrapped up. The court isn't going to go out and investigate Chile. The court doesn't really fucking care. If you make a reasonable allegation supported by a reasonable number of facts that someone is assisting a pro per litigant in the unlicensed, unauthorized practice of law, the court is going to do the minimum. It's the minimum, okay? What the court is going to do is the court is going to say, here's an order saying that guy can't help you practice or with the practice of law. That's what the court's going to do. The court is not going to want to make Chile a party. There's no nexus of facts and law that would make joinder something that the court's going to want to do to bring Chile in, to allow for discovery. It's not a thing. So, and the court's not looking to sanction Chile. The court's not looking to get charges pressed. The court's not looking for anything like that. All the court's going to do, I am 99.9% certain. Obviously, I could be wrong because courts can do what they're going to do, but I've never seen a court do more. You can't find me a case where the court did more than say, you don't practice law. You can't assist the plaintiff in representing him. You can't assist the plaintiff in preparing his pleadings or motions or anything like that. That's it. That's all the court's going to do. And the court's going to have authority to make that kind of order because those pleadings and things are coming to the court. And the court's just basically saying, you can't do that, buddy. You're not part of this case. You can't do that. You're not an attorney. You're not representing them. You can't do it. And that's where the court's going to draw the line. So the lawyer doesn't have to prove that Chili's still filing paperwork for Wallace. Oh, I see what you're saying. So if the court issues the order, I get it. If the court issues the order and Chili continues, what would happen then? Well, what would happen then? Chili would be setting himself up for contempt of court. It would probably be direct contempt because these pleadings are getting filed in front of the judge or to the judge. I would guess. I could be wrong, but it would probably be criminal contempt, and he could, in theory, be jailed for it, fined for it, or both. And because that would be a federal punishment, the state would still be able to then go after him for the unlicensed practice of law, the unauthorized practice of law, for state charges. And if he's already been convicted in the federal court, it's going to be pretty easy to get a conviction in the state court. So it wouldn't be up to the lawyer necessarily to prove it. So what would happen? What would happen is the lawyer would probably file a motion of some sort and include a declaration about why the lawyer thinks that Chili's still practicing law in the particular case. And then what the court would likely do at that point is issue an order to show cause regarding contempt. And that means that Chili's going to have to come in and explain why he's not practicing law to the court. And then if the court found that to be unsatisfactory, then the court would issue sanctions up to and including jail time. So there, I think I hope I've answered your question. All right. Chili didn't get busted. Okay, you're welcome. You're welcome. You have a good night too, Neva. Chili would have to go full Blandino to do that. It takes a lot. It takes a lot to get the attention of the authorities. They have better things to do and easier things to prove. I wonder if they can compare IP addresses for this filing to Chili's computer. I bet LVMPD has a large cybersecurity department. I don't think they're going to waste their time or trouble to do it. Every time people have said he's engaged in the unlicensed practice of law, all the time people have done this. Who was that one guy who was helping PayPal Patty, and then he started helping Chili, and Chili referred to him as a legal expert and was holding him out to prepare motions, and the guy was just a total scam artist. Him and his wife were sovereign citizens. I forget Fred Gutierrez. Yeah. What happened to Fred? Guess where Fred lives, kids? Fred lives in Nevada. What's happened to Fred? What do you think is going to happen to Chili? Well, nothing happened to Fred. Probably nothing's going to happen to Chili. Like, I get it. You guys want bad things to happen to Chili. I don't think it's going to happen. I think the judge OT'd it. Okay. All right. Thank you. We can see your cocks. Nice. They're big enough to be seen on the live stream. Okay. Oh, you're welcome. Glad I could answer your question. Bobby Lau. Yep, Fred Gutierrez. Yep, Fred. So if there's no real outcome from this motion, what's the point of filing it? Well, so there is a point to filing it. It's going to put Chili on notice because there's going to be an order out there don't practice law. Don't help Wallace. It's the first step. You guys want instant justice. You guys want vigilante justice. That doesn't work that way. Again, first step is the court's going to issue an order. Second step is if Chile violates that order, the court will issue an order to show cause. Then bad things could theoretically happen to Chile. Is Merb's cock in his briefs? What briefs? Do you think there should be speed limits on public roads? Do I think there should be speed limits on public roads? You're the drunk driving guy. You're the guy who's all mad because I don't think that drunk driving in and of itself should be a crime. So, okay, let's play. We'll play a game. Do I think there should be speed limits on public roads? Yes and no. I think where it makes sense to have a speed limit, there should be a speed limit. And where it doesn't make sense to have a speed limit, I think that people should drive at whatever speed they feel safe. However, they should be fully responsible for whatever harm they cause, and up to and including vehicular manslaughter if they're going faster than they should on the road. My cocks make the briefs. Nice. Okay. It is you. Yeah, I could smell you a mile away. You're not a good guy. You're an annoying guy. Courts have a lot going on. These bullshit lawsuits are not high on the list for the courts. Yes, that is right. Okay, so we've reached the end. Thank you very much for watching, and have a wonderful day.